The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. I'll ask those lawyers who are not in the first case to please mute your sound and video, please. All right.
Good morning, Your Honors, and may it please the court. Samantha Shea, Cara Coalition, for Petitioner Maria Aritas-Deris. The board's decision must be reversed because it ignores undisputed record evidence and misapplies key legal standards for past persecution, corroboration, and nexus between past persecution and a protected ground. I will be discussing the issues of past persecution and corroboration. My co-counsel, Ms. Berman, will then discuss nexus. Your Honors, the facts in this case are not contested. We know that because Ms. Aritas-Deris testified as to each one of the key facts for her claim, and the immigration judge found her testimony credible. Starting in 2008, Ms. Aritas-Deris and her family were relentlessly threatened and attacked by a local gang leader, Ricardo, who was jealous of Petitioner's husband. Ms. Aritas-Deris and her family moved twice, but the threats continued. And in 2011, Ricardo killed 3 of Petitioner's family members, her 2 brothers-in-laws and her father-in-law. He shot at
Counsel, where is the immigration judge asked for corroboration of items, including the ones you just mentioned, which I did not find in the affidavits that were submitted. How were those items corroborated, other than by her own testimony?
Sure, Your Honor. Respectfully, these details actually are in the affidavits. For example, Ms. Aritas-Deris's, her husband, and her sister-in-law's statements discuss the language of the death threats Ricardo sent to her. And that's on pages 308, 312, and 330 of the administrative record. And so all of these statements discuss the language Ricardo used to threaten Petitioner, in which he specifically says he is targeting her.
Well, if I could interrupt you for a second, one of the things that I think concerned the immigration judge, and what I'm asking about, is there's never a discussion by anybody of this fellow Ricardo or the rationale or any of the other people that she mentions. And the immigration judge asked for corroboration in that regard. But I'm not finding that in any of these affidavits that were submitted. Can you show me specifically where that appears?
Your Honor, so the affidavits and statements from the family members do not mention Ricardo by name. They instead refer to him as her husband's enemies or the gangs generally. And there's actually no requirement that an asylum applicant has to give the exact name of his or her persecutor in order to qualify for asylum. But I also want to note that almost 2 years before Petitioner had her merits hearing before the immigration judge, she had her credible fear interview. And that's when she actually mentioned Ricardo by name several times. For example, on page 450 of the record, she identifies Ricardo as her husband's enemy. And this corresponds to the use of the term enemy in Petitioner, her husband's, and their families' affidavits and letters.
Well, I don't think there's any doubt that she uses all those terms, but I don't find anything in Mr. Vidal's affidavit that corroborates that. I mean, the enemy could be anybody.
Well, Your Honor, her husband's affidavit does not name Ricardo, but it refers to him as a gang member and discusses in great detail his reasons for targeting Petitioner, which is all we need to show for nexus, that the persecutor was targeting Ms. Aritas-Deris based on her membership in her husband's family. I also want to point out additional pieces of key evidence. We have the independent documentation of the 3 family members' murders, the burial permits, the death certificate, and the certificate of corpse removal. So on page 349, we have the certificate of corpse removal actually for the father-in-law specifically states that he was murdered and that his body was found discarded on the side of the road, riddled with bullet holes, which is directly in line with Miss Arita Darris's testimony on the circumstances of her father-in-law's death. And I also want to circle back to the affidavits and letters Miss Arita Darris submitted from her and her family members. She submitted affidavits from her husband, and her brother-in-law elder, in addition to letters from her mother-in-law and sister-in-law. And again, these documents discuss in detail the murders and threats that Miss Arita Darris and her family suffered, but they also further go into why Ricardo was going after petitioner. That is why he was going after her based on her membership in her husband's family. For example, we have her husband's and her sister-in-law's statement, which discuss the language of the death threats. And this is on its own sufficient to show nexus for her claim because the death threats qualify as past persecution, and they're clearly targeted towards her based on her relationship to her husband, given that they specifically reference her husband's name and admit that they are targeting her based on her husband. I also want to direct this court to page 356 of the record, which is her brother-in-law elder's affidavit. And her brother-in-law actually received asylum on the exact same basis that she is now seeking asylum. That is based on his membership in his brother's family. And so Elder says, "Our family is in great danger from my brother's enemies, especially his wife and their children, because our enemies know that hurting them would really hurt my brother." These are just some of the many instances in which these documents address nexus and the key events underlying petitioner's claim. In finding that petitioner did not sufficiently corroborate her claim, the immigration judge applied erroneously heightened standards to require independent objective evidence of nexus, the in-person testimony of petitioner's husband, a witness whom petitioner could not compel to testify in person, and requirements for affidavits that are not based in law. First, the immigration judge's clearest error is requiring that petitioner submit independent objective evidence of nexus without specifying exactly what evidence he was seeking, nor making a finding on whether such evidence was reasonably available. And this is in direct violation of this court's recent decision in Wambora, and also its earlier decision in Lin Jan. The immigration judge's requirement that her husband testify in person is also reversible error. I want to be clear and say that we don't need her husband's testimony to corroborate for nexus, given that the death threats Ms. Arita Darris received on the basis of her relationship to her husband are on their own enough to entitle her to asylum because we have past persecution that is clearly on the basis of her relationship to her husband. And in requiring the husband's in-person testimony, the immigration judge was actually seeking corroboration for an issue that is not relevant for nexus. The immigration judge makes several statements indicating that he's confused about who has to show nexus for Ms. Arita Darris's asylum claim. For example, on page 177, the immigration judge says, "This case is driven by the fact that there's some vague..."
Well, counsel, in this case, the immigration judge said, what's the reason that your husband isn't here? And the answer given was, well, he's in the country illegally, which would be true in almost every case where they're looking for a witness. But it seemed odd in this case where they live in the same city where the proceeding is taking place. The immigration folks obviously know where they live because they send notices to their home, and Ms. Vidal has had given them her address and told them where they live. Why is that an unreasonable request?
Well, Your Honor, it's unreasonable because she asked him to testify and he refused, so his absence was out of her control. And instead of his in-person testimony, she submitted an affidavit from him. And again, I want to emphasize that.
Ms. Tsai, we have some prior cases that discount the importance of affidavits as corroborating evidence. Our Singh case, our Ganziami Mikhail case. How do you reconcile the language in those cases with what you're asking us to do today with regard to the weight of the evidence?
Sure, Your Honor. So this court has never held in a family-based claim that affidavits and letters from family cannot constitute corroboration, which makes sense because in these types of asylum cases, the statements of family members are often the only evidence someone can submit to support their claim. And I also want to direct this court to the Mbala Boba versus Sessions case, which is actually the most recent case from this court on this issue. It's from 2018, and this court recognizes that family statements can constitute corroboration. And I see I'm out of time, Your Honors, but I do have a few additional points I'd like to address.
All right, Counselor, I'll give you a few minutes. Go ahead.
Great, thank you, Your Honor. And going back to the husband's absence, the record is clear that the immigration judge was clearly confused as to who had to show nexus and who had to show entitlement to asylum. On page 225, he says, your husband is the one who has the principal asylum claim here, and he can't connect the dots. He's referencing the husband's absence. In Jin Tao Lin versus Holder, this court actually addressed a situation in which a potential witness did not appear in person to testify for an asylum applicant's claim because they were undocumented. This court actually expressed significant doubts regarding that immigration judge's ruling that petitioner's wife, who had a final removal order, was required to testify in person and that she was an available witness. And I also want to note that here, Ms. Rita Darris has an even stronger reason not to have her husband testify in person because she had submitted an affidavit from him, and the record is clear that she asked him to testify, but he refused. The immigration judge also labels her husband a self-interested witness on page 34 of his decision, on page 34 of the record. So we're not even sure if her husband came in to testify, if the immigration judge would have accepted the husband's testimony. In this case, Your Honors, the immigration judge was essentially imposing moving targets for corroboration. Mr. Rita Darris testified credibly and in great detail regarding all the important facts for her claim. He then required corroboration. But when she submitted statements from her family members, he said that wasn't good enough because she needed to submit unspecified, independent, objective evidence of nexus. When she submitted an affidavit from her husband, he said that wasn't good enough because the husband had to come testify in person. But he also indicates that because the husband is biased, he might not potentially accept his testimony. And Your Honors, I just have a few additional points on the immigration judge's rulings on these affidavits as lacking.
Well, Counsel, your time is up, so I'll give you one more minute, but you will be heard from your side.
Sure, Your Honor. I will wrap things up quickly. So the immigration judge says that these affidavits are lacking details, but these affidavits actually contain many of the details the immigration judge contends are lacking, such as the time and location of events and Ricardo's motivation for targeting Ms. Rita Darris and her family. And for these reasons, Your Honors, this court should reverse the agency's erroneous corroboration ruling. If this court has no more questions, I will turn it over to my co-counsel, Ms. Berman.
Thank you, Counsel. Ms. Berman?
Good morning, Your Honors. Amanda Berman from Crowell & Mooring. I'm going to be focusing on the nexus issue here. The Board of Immigration Appeals did not apply the correct legal standard when assessing whether there was a sufficient nexus between petitioner's membership in the particular social group of her husband's family and the persecution she endured. Basically, neither the board nor the immigration judge asked the right question, which was whether record evidence shows that petitioner's family relationship to her husband was at least one central reason why she was targeted. And Your Honors, that's the same mistake that the board made in the Hernandez-Cartagena case, in which this court recently overturned the board's decision and directed a grant of asylum, because the violence against the petitioner like here, was caused at least in part by her familial relationship. Just as the court found there, once the right question is asked, and that is why was petitioner being targeted, the conclusion is quite clear. Whatever the gang's motives for targeting her family, petitioner was targeted because of her membership in that family. And that is the same thing that is true here. And Your Honors, I would point this court to the immigration judge's own summary of the key testimony on nexus. And you can find this in the record at page 63. And the immigration judge at page 66 finds this testimony credible. His own summary states that Ricardo's gang repeatedly threatened to kidnap and kill Ms. Arita Darris and her son in order to try to get her husband to come back so they could kill him. And the immigration judge also found credible petitioner's testimony that other members of the very same particular social group, the same family, were killed by the gang in order to hurt petitioner's husband. Your Honors, it's hard to think of facts that more clearly show persecution based on membership in a family. In fact, as in the Diaz-Velasquez case this court decided in 29, the familial relationship is the only fact in this record that can explain why the gang targeted petitioner and not someone else. And that's more than petitioner had to show. She only had to show that membership in her husband's family was at least one central reason why she was targeted. Instead, the immigration judge characterized the violence she faced as general criminal violence by private actors. But in doing so, it essentially ignored the at least one central reason standard. Stating that a person is the target of general criminal violence by private actors does not mean, as a matter of logic, that they were not also targeted because of a familial relationship. To put it another way, the board's conclusion that the persecution was the result of general criminal violence doesn't answer the question of whether Ms. Arita Darris was targeted for such criminal violence because of her membership in her husband's family. And Your Honors, any violence by non-state actors could be targeted as general criminal violence by private actors. The board also erred here by ignoring that the immigration judge was plainly not applying the particular social group analysis and nexus requirements properly. He characterized petitioner's claims as subsidiary to her husband, saying it's your husband who has the primary asylum claim here. And that's simply wrong as a matter of immigration law. The INA gives petitioner a direct claim as a member of a particular social group. The judge also told Ms. Arita Darris that what he cared about was not, why is the gang targeting you, but why are they targeting your husband? And you can see this at pages 177 to 78 of the record. Again, that's simply not the right legal question on nexus. As stated most recently in Hernandez-Cartagena, the right question is whether petitioner's familial relationship is at least one central reason why she was persecuted, not the sole reason, not whether can the violence also be characterized in some other way, like as general criminal violence, and not why was the family targeted. And Your Honors, this is not the first time that the board has made this mistake. In the Hernandez-Cartagena case, while I think it is beautifully on point, was no change in the law in this regard. Rather, this court has had to correct the board again and again on this issue. It did so in the Diaz-Velasquez case in 2019, in Salgado Sosa in 2018, Hernandez-Avalos in 2015, Cruz 2017, Cordova 2014. And in several of those cases, this court called out the board's, and I'm quoting here, excessively narrow view of the nexus requirement as a consistent error. The board made the same error here. And finally, Your Honors, the board also improperly suggested that petitioner's particular social group is not a valid one based on the Attorney General's recent decision in matter of LEA. And that belief appears to have improperly influenced the nexus decision because it immediately precedes it. And the nexus decision is then very short and cursory. Now, the government has conceded in its brief that it cannot defend the board's decision below based on matter of LEA. And it says that the board accepted the particular social group. And yet in footnote 15 of the government's brief, it asked this court to remand the matter to the board if this court agrees with us on the nexus conclusion, so that the board can then decide whether this family is a particular social group. Your Honors, this court should not do that here. We explained in our brief why the dicta from matter of LEA that suggests that average families will not qualify as particular social groups is wrong as a matter of law. That is including because this court has repeatedly held otherwise in a line of cases that includes most notably the Crespin-Valladares decision, and this court said that again most recently in Hernandez-Cartagena, and that was after the Attorney General's decision in LEA. And even if that dicta in LEA were sound, it cannot be applied retroactively to asylum claims that predate us. We went through the retail wholesale analysis on that point in our brief. Therefore, Your Honors, I would ask that, as this court did in the Hernandez-Cartagena case, this court can and should reverse on the nexus point and reverse the board's decision and hold that petitioner was persecuted on account of her membership in a particular social group consisting of her husband's family. Thank you, Your Honors.
Thank you, counsel. Mr. McCarter?
Thank you, Your Honor, and may it please the court, Trim McCarter from the Department of Justice on behalf of respondent. I don't want to spend too much time on it, but I did just want to mention very briefly that if the court wishes to invoke it, the fugitive disentitlement doctrine would apply here. It's obviously an equitable doctrine, not jurisdictional, and I prefer to spend more time on the merits, but I did want to raise that point briefly, Your Honor. On the merits, petitioner seems to suggest that because the IJ found her credible, that we must accept everything she said is true, including this linchpin fact that Ricardo was kind of the mastermind persecutor behind everything. But that's not true in a case where the immigration judge properly asked for corroborating evidence. Under the Real ID Act, 1158 B1, B2, and this court's decision in Lin Jian, which was 49 F3rd 191, even for credible testimony, the IJ can ask for corroboration. And of course, what that means is that if the IJ asks for corroboration properly but doesn't get it, then it's the same ultimate outcome as if the petitioner hadn't been credible in the first place. Essentially, the petitioner hasn't demonstrated her case. And here, the IJ did properly ask for corroboration, as this court held in Singh 699 F3rd 331. The immigration judge was not fully satisfied with her story.
Okay.
Yes, Judge.
What kind of corroborating evidence are you saying would have been necessary in this case?
So I don't think there's any particular piece, Your Honor, that's a linchpin, absolutely necessary type of document or testimony. But
right. But, you know, you need to give us a little bit of kind of flesh on the bones here so we can understand what you're saying. I mean, we've got a lady here who testified very specifically. We have our Bedoya case very recently talking about death threats being evidence of past persecution. She had her family members' burial permits here. It wasn't just the affidavits, the burial permits of the family members who were murdered. So what was necessary here? Are you maintaining that her husband had to have come in order for her to prevail?
A few responses, Your Honor. I agree that she did document the deaths of the family members. That's not really the issue. That's not where the lack of corroboration comes from. The lack of corroboration is about Ricardo's involvement. That's her theory, that Ricardo was the persecutor. And on that, she could have introduced more detailed declarations. Out of all the declarations she introduced, only one mentioned Ricardo, and even then it was only once. Her husband could have testified. The IJ didn't say that the husband absolutely had to testify, but the petitioner kept saying that she had no personal knowledge about whether Ricardo was the one behind all this. She said it was all what her husband was telling her. And her husband did submit a declaration, but again, it doesn't mention Ricardo even once. So the husband could have testified and provided some backup there to help corroborate her story. The petitioner mentioned that a nephew had confirmed that one of the threats she claimed she got on her phone was in fact from Ricardo, that he recognized the phone number. So a declaration from that nephew that would tie the threat specifically to Ricardo and confirm her story as to how this is all happening.
Mr. McCarter, may I ask you a hypothetical?
Of course.
What if it wasn't Ricardo at all, but instead it was someone else who the husband didn't want to name, but nonetheless that unnamed person was angry with him and targeted his family? Would it make any difference that she didn't know who Ricardo was? As a matter of fact, Ricardo had nothing to do with it, but instead it's an unnamed person that her husband didn't tell her? but he was targeting the family and threatened, as the records demonstrate here?
I think,
Go ahead.
sorry. I think kind of as a theoretical matter, Your Honor, it wouldn't matter if they could identify that it was in fact someone who's behind it all. I'm not saying she had to identify a specific person, but the point is it's kind of twofold. She does identify Ricardo. That's her story the whole time, and she can't corroborate that particular aspect. But also, if she can't confirm that it's at least the same persecutor who's actually doing all this, then there's a lack of corroboration for that, Your Honor. Otherwise, it's no different than being the victim to several seemingly unrelated crimes that everyone kind of assumes is chalked up to the same person, whether it's Ricardo or someone else. So it's kind of twofold, Your Honor. In this case, I think that she's pinned her argument on Ricardo. And also, even if it weren't Ricardo, she hasn't identified that it's a specific persecutor who's coming after her. Because of that, that's why she has no corroboration on that specific point.
Well, does it need to be a specific persecutor, or does it need to show that persecutor or persecutors were targeting her family and her as a member of that family? It seems to me maybe you're placing a little bit too much reliance on it being an identifiable persecutor. As long as she is the target and her family is the target, and we've got the dead relatives, people being murdered, why isn't that very strong circumstantial case? It seems to me that you're asking for direct evidence when that may not be required.
I agree it doesn't have to be a specific person necessarily, Your Honor, but of course the intent of the persecutor is the key issue here. And if we don't know who these persecutors are, or whether it's one person, or whether it just happens to be random gang violence or other violence that's unaffiliated, then we can't say that she's actually being targeted because of her protected status, Your Honor. So I think that's why it was so important, especially given the way petitioner framed her case, for her to come forth with evidence after the IJ asked for it, that she actually is the target of some scheme here. And especially given that she focused so much on Ricardo, that Ricardo was the one behind it, Your Honor.
And she was also shot at when she was in a vehicle too, wasn't she? I mean, that's pretty compelling.
She claimed that, Your Honor. Again, that was something that wasn't corroborated. Her husband, remember, had listed the same story, kind of copy and pasted in his declaration. Didn't say Ricardo was behind it or anyone else in particular.
But all of her threats were framed in the reference to her husband was the basis, was the core of it, wasn't it? We're doing this because we want threatened kidnap and harm to her because we want to try to get your husband back into the country. There was no question that everything was framed. It was never framed like somebody's after me. I don't know why. The why was always connected with her husband and her familial relationship with him.
I agree. She certainly testified to that, Your Honor, and those were her allegations. But then again, she didn't have corroboration to back it up.
Again, you're saying her husband needed to come in and say, yes, this man is after me.
It didn't have to be her husband. I think he would have been an excellent source, and that's what the IJ says, Your Honor, that the husband was the source of all the information, or almost all the information that petitioner testified to. So the husband would have been an excellent source. I mean, it's just as an aside, I think perhaps the husband could have come in by video or some other way. We don't know for sure. But it's not necessary that the husband testify and that is the whole reason the petitioner lost. There were other bases the IJ listed as the ways that she could corroborate her claim. As I said, declarations that actually talk about more specifically who the people are to show that there actually is a scheme to attack her husband's family, as opposed to this being kind of unaffiliated, unrelated violence. And remember, Your Honor, Honduras does have the highest murder rate in the world. And so it might not be that unusual that over the course of several years, a single family might have several family members who are unfortunately the target of violent crime. And so I think given that the IJ had asked for corroboration, and given that petitioner wasn't able to come back with anything, even though there were several specific findings by the immigration judge at pages 7 and 8 of his decision, that evidence would have been reasonably available, which is the Real ID Act standard, that resolves almost all of petitioner's case.
What are we to make of the fact, the comments that, well, perhaps if the husband came in, he would be a self-serving witness? Wouldn't that suggest that it's a catch-22 for her?
I think the immigration judge was just citing this court's decision in Singh, Your Honor, 699 F3rd 331, I think it is, that says that declarations or statements from family members, they're not always entitled to full weight. I don't think the immigration judge would have just completely discounted a husband's statement. It would depend on the detail and everything. But this court said
that may be your thinking, but what he said was it would be self-serving.
Right.
That's pretty much a finding of fact, isn't it?
I think it's more of kind of perhaps a prediction, Your Honor, of what the husband might say.
How would that be a prediction? It's not a prediction. He said it would be self-serving.
I think he's just relying on this court's decision in Singh, Your Honor, which does say that it's troubling to rely on declarations from family members. It's not that they're not entitled to no weight or that we just shouldn't count them at all, and therefore the IJ is asking for something, but then saying, but if you don't give it to me, or if you do bring it to me, then I'm not going to count it. I think what he's saying is the husband could be a very excellent source of corroboration, but I will note, as the Fourth Circuit has held in Singh, that family member declarations kind of, or statements, are often taken with a grain of salt, and that's what this court held in Singh. So I think that's what he was relying on, Your Honor. And kind of back to the point of corroboration and a little bit on the point of nexus, there were several places where petitioner herself had talked about that she was kind of speculating as to who was behind all this. She had said at 2:53 that she doesn't know exactly whether Ricardo was behind everything. At 2:26, she says that she's not basing it on anything, that her father-in-law's death was caused by Ricardo or his gang. She does the same for the drive-by shooting at 2:14. She says she doesn't know who's behind that. For the deaths of the husband's brother and brother-in-law, again, she says at 2:06, I don't know exactly who was behind it. For the 3 armed men, she said that she saw outside of her house at 2:32. She said, I don't know who they were.
But aren't you doing exactly what Judge Keenan talked about? You're mounting up some circumstantial evidence. You're naming all these close relatives who were murdered and say, well, she didn't know who it was. That's all corroborating, really, exactly that. It shows her honesty. I don't know these people by name, but I know they're attacking my family, and we're dying.
It is her testimony, Your Honor.
That's all she has is her testimony, her desperation, her testimony. What other stock in trade does she have in a case like this?
She could have, as I had mentioned earlier, Your Honor, declarations from the nephew who apparently had tied these alleged threats to Ricardo himself. She could have copies of the threats, copies of police reports that mention these crimes and perhaps attach it to Ricardo or his gang. Again, she could have had the husband come in, Your Honor, that sort of thing. Those are the things she could have had to bolster when the IJ says that he generally believes the petitioner, but he wants more evidence to back it up. I think what the IJ is saying is that the petitioner herself genuinely seems to believe that Ricardo and his gang is behind all of this, but there are some logical gaps here that don't quite explain why Ricardo would actually be the one, or his gang would actually be the one behind it all. And that's why he wanted corroborating evidence, Your Honor, which the Real ID Act allows him to do. And then, as we've discussed at length, petitioner wasn't able to come in with anything more specific. And on the question of kind of the gaps in her own testimony, she had mentioned, of course, that she had never been injured by Ricardo or his gang. She said during her asylum interview at 4:53, quote, they never threatened me. And at 2:34, in front of the immigration judge, she said, perhaps they, referring to Ricardo and his group, perhaps they didn't even have the intention of harming us. And it seems like the IJ largely just agreed with that. And given the substantial evidence review standard, Your Honor, I think that is probably enough to resolve that issue. And of course, the IJ also pointed to the fact that Ricardo allegedly had a 1.5 years where petitioner and her son were kind of exposed by themselves and didn't try to attack. 2 years where Ricardo could have attacked her husband any day and didn't try. So there's the corroboration issue that we've discussed, and then the facts that I just mentioned go, I think, more to the nexus issue of whether there's actually a tie to the family here. Of course, the husband's mother, brother, and sister all still live in Honduras the last 10 years, apparently without any issues. So when you kind of put it all together, Your Honor, we've got no documentation about Ricardo or his involvement, even after the IJ asked for it. And petitioner herself says she isn't sure. And that's just not the kind of compelling evidence that would be required under the very heavy standard of review in this case, Your Honor. And I don't mean to diminish the crime and the violence that her husband's family has been subjected to. I just think the immigration judge and BIA had enough evidence to support their conclusion that there wasn't corroboration for Ricardo, for the scheme, for the gang of this all being persecution. And that resolves petitioner's asylum claims, Your Honor. There were a couple points, if I could, that I did want to address briefly based on arguments that my friends made on the other side. On the one central reason test, Your Honors, the BIA did quote the proper test at AR page 5. So the BIA was fully aware of the nexus standard here, Your Honor. And I know the petitioners disagree about whether it was applied correctly, but the BIA certainly was aware of that standard. On the IJ's few stray remarks he had, for example, the statement that the husband has the principal asylum claim, that tracks almost verbatim what petitioner's own reply brief says at page 12, footnote 3. They say the petitioner's asylum claim is predicated on her husband. So I think the IJ probably just meant what petitioners themselves meant in that footnote, which is that petitioner's claim kind of rests factually on her husband and whether his family is being targeted. And the IJ was just pointing out, well, even the husband doesn't seem sure that this is what's going on. It's kind of just trying to keep the testimony on point, focused on that issue. And it was the same with another point that my friends had mentioned, that the IJ said he was interested in why Ricardo and his men were targeting the husband. Again, that's just the immigration judge in the context of the transcript, just the immigration judge trying to keep petitioner focused on that particular aspect of her case before moving on to why Ricardo might be attacking petitioner herself. And one final, my friends mentioned the Wambura decision from this court that recently came out about whether the corroborating evidence would be reasonably available. The BIA did say that the evidence that the IJ had asked for would be reasonably available. That's AR page 4. The immigration judge twice said at pages 7 and 8 of his opinion that he thought the evidence he was asking for would be reasonably available. So he did make those findings, Your Honors. And just as an aside, the petitioner didn't raise this argument before the BIA, and of course that's a jurisdictional defect under this court's decision in Cabrera, but not that the court would need to reach that, but I just wanted to address that briefly. And I think on the matter of LEA, Your Honors, I filed the 28J on that issue. I think that the BIA didn't rely on that. There's no evidence they did, and so this court doesn't need to reach that issue. And unless the court has any further questions, I would just rest on my briefs, Your Honor.
Thank you, Mr. McCarter. Ms. Berman?
Yes, thank you, Your Honors. I want to follow up on a couple of points that my colleague for the government addressed. First, it doesn't matter who was the mastermind persecutor, as he said. That simply doesn't matter. What is clear from the affidavits, as well as Ms. Arita Darris's own testimony, is that a gang, one set of enemies, was persecuting the family in order to get at the husband. You cannot read the affidavits and come away with the conclusion that it could possibly have been all random acts of disparate violence. That is completely inconsistent with the affidavits, with her own testimony. Ultimately, it doesn't matter if the gang was led by a guy named Ricardo or not. It was a gang that was targeting her because of her relationship to her husband. And she did have the personal knowledge of why she was being targeted, which is the key point here in regard to both corroboration and the nexus issue itself. You know, my colleague for the government pulled out this list of statements where she admits she doesn't know things. She admits, I don't know, I don't have direct firsthand knowledge of who murdered my husband's father and brothers. They didn't leave notes by the bodies. But what she does know is that she got 2 notes at her house. Meanwhile, while she was in hiding at a relative's house and not staying there in order to avoid meeting the same fate, she gets 2 notes at her own house that she testified say, we're coming after you and your son in order to get Pineda Vidal to come back to the country so that they can kill him. And again, the immigration judge's own summary of her testimony, which he found credible, is that Ricardo directly sent Ms. Arita Darris text messages as well, saying that he was going to kill her and her son to get the husband back. That is really all that is needed to substantiate her claim, which is based on her connection to her husband's family. Your Honors, I'd also like to point out that contrary to what my colleague from the government just said, the immigration judge did not make the finding that's required under Wambora, that there was some particular piece of corroborating evidence on the nexus issue that was reasonably available and that petitioner didn't provide. He didn't identify something like, for example, you should have given me the notes. He didn't say that. He, asked her, why don't you have them? She explained that she had not kept them. He didn't question that or say that's what I need. It was a very general statement. The separate conclusion that the husband should have corroborated his own written testimony by appearing in person to testify doesn't fill that gap in any event. The husband could not have testified about those notes, those threats that she personally received as to what they said and why the gang was targeting her. He wasn't there. He was already in the United States at that point. In short, Your Honors, the judge was seeking corroboration on the wrong issue here. He wanted to know why petitioner's husband was targeted, and he wanted petitioner's husband to come in and explain that. That issue is legally irrelevant. Again, it all goes back to the judge was not asking the right question. And finally, I want to briefly address the fugitive disentitlement doctrine, since my colleague brought it up. Your Honors, an argument that is made in passing is not an argument under this court's precedent. An argument that is not made in the argument section of a brief is also not an argument. An argument in a footnote outside the argument of section of a brief is even less than an argument. This court has never applied the fugitive disentitlement doctrine. It certainly should not do so for the first time, where it is not properly raised, where we have not fleshed out the facts that the government hasn't even identified, the facts that it thinks make this doctrine applicable, or explain the legal standard that it thinks applies under the precedent out there on this, which varies from circuit to circuit. So, Your Honors, even the government says this is in any event just an equitable doctrine. This is not a case where the court is compelled to apply it, and it would certainly be inequitable to do so here under the circumstances where it hasn't been properly raised. So if there aren't any other questions, I will rest on our briefs at this point.
Right. Thank you very much, counsel. We can't come down and greet you as we would in our normal tradition of the Fourth Circuit, but please know that the sentiment is just as strong, and very much we appreciate your arguments and helping us on these cases. Be safe and stay well. Thank you, counsel.
Thank you, Your Honor.
Your Honors.
We'll proceed to our next case. Thank you.
Good morning. My name is William Davis. I am appearing on behalf of the Public Interest Legal Commission and may it please the court. I believe I reserved 5 minutes for rebuttal. This is a case that was brought below incidental to the or pursuant to the public disclosure provisions of the National Voter Registration Act. Would be section AI1 of the Act. The documents in question are documents which relate to the determination of registration of individuals and the removal from the registration rolls by virtue of a finding of non-citizenship. The trial,
Mr. Davis, if I could ask you at the outset, other than voter registration applications, what exactly do you say you are due that you have not received? It's very hard to tell. It's very hard to tell going through here what documents you want and the basis for the entitlement.
Working backwards, the basis for the entitlement would be the plain language of the statute, which requires the production of all documents that were generated with respect to the implementation of programs or activities related to list maintenance. And the citizenship verification clearly falls within the ambit of that definition under the statute. And the documents in question would be whatever was received by the agency upon which they made a determination of citizenship for verification purposes. That we never got to the stage where there were particular documents that were identified at all, because what the court did but crafted an exemption, the statute, based upon the notion that the documents could be uniquely sensitive and or subject to some form of abuse, and then concluded that these documents, whatever they are, because we don't know, would fall within the ambit of that exemption. It's our position that that exemption, number one, does not fall within the statute. The statute only has 2 exemptions that it's been recognized.
Well, it just seems very difficult for us to apply this statute when we don't know the documents or what the documents contain. We're just kind of guessing hypothetically. I mean, it seems like to me that this case would have been much better presented if the parties had gone to the district court and you'd at least identified the documents that could be available, so then both the district court and this court could make some judgment about whether or not there should be documents released or documents withheld.
We agree with that, and the problem is that the documents were identified by the state. So what we requested was very specific. There was no specific identification, like in the Project Vote case. At least there was a determination that documents contain social security numbers, and they redacted the social security numbers and cleared up any infirmities with regard to production of documents. In this particular instance, we never got to that phase. What we got was the trial judge created this exemption, which basically had no limiting principle whatsoever and was subjective. And we're in a situation where we don't know what we don't know by virtue of the fact that we never went beyond the 12B6 motion practice.
Okay, but Mr. Davis, I think what Judge Agee is asking you, and something that's of concern to me, is it seems like your request has no limiting principle. What does the statutory language mean, all records of programs and activities? Do you have any authority for what that statutory language means? Because we're going to have to make that determination, and it seems like you're just saying it's everything we want, and
Well, I would
to have something more specific. So could you help us and guide us in that respect?
I would point the court to the project, this court's 2012 project vote versus long decision. And at page 331, it makes reference to the particular document provision of the National Voter Registration Act. And it basically says, without verification of an applicant's citizenship, age, and other necessary information provided by registration applications, state officials would be unable to determine whether that applicant meets the statutory requirements for inclusion in official voting lists. And then it goes on to say,
excuse me, what page are you reading from?
It's page 331 of the decision. It's 682, 3rd, 31.
331 is the first thing on the decision.
Yeah. Mr. Davis, you're sort of out of context. What the court was saying there was describing why receiving a completed registration application matched perfectly with the language of the court, saying that, well, you needed completed registration. That's certainly a part of the process and the task of maintaining the list. But going back to Judge Agee's question and Judge Keener's follow-up, you don't have before us what you want. There, they were looking at a completed application registration, and they said, looking at that, the language was plain as to the statute. Didn't say that for every request. We don't have any context for it. Ben, go ahead.
I'm sorry, the specific requests were documents regarding registrants who were identified as potentially not satisfying the citizenship requirements for registration from any official information source, including information obtained from various agencies, which are specifically particular. And then there's a subsequent request where the specific registrant had requested removal from the voter rolls by virtue of an issue relating to non-citizenship. So those were the two requests for the court. And then I'd like to...
Well, if I could, I mean, was that done through discovery? I mean, did you submit interrogatories to the state and ask them to identify all the documents, at least generically, that might fit within these requests so that you would have some frame of reference?
It was not done through discovery. It was done through requests prior to the filing of the suit, and then it was done in the suit, and then the court dismissed the action on a 12B6 motion. So it never got to the discovery phase.
Are you asking for a list of names?
No, we're asking for the
potential non-citizens. What are you asking for?
Well, we're asking for where there are determinations of citizenship and there are registrants that are removed from the voting roll. We're asking for the underlying documents that would reflect the activity and the program that results in that administrative act.
So you want law enforcement records then, essentially?
No, we're asking for what the Board of...
Okay, just one sec. Aren't these people under investigation and with potential criminal consequences? And it seems to me, I've been struggling to figure out whether there's any other law enforcement investigation involving potentially felonious conduct that's got to turn over its file. And it seems to me that that's what you're asking for, is for the Board of Elections criminal investigation file.
We're not asking for a criminal investigation file. What we're asking for are what basic documents they would rely upon in removing registrant for citizenship or non-citizenship reasons. And the remedy isn't necessarily a blanket denial of those documents. To the extent there's information in those documents would otherwise be sensitive or render them vulnerable to abuse, it's redacted. We're submitting here, we never got to this point because the 12B6 motion was granted. And in answer to Judge Ajiz's question a while ago, I'd like to point back to on page 31 of the, I'm sorry, 335. I misread it. The scope of the public disclosure provision, the NVRA, is pretty much articulated there. It says, finally, the fact that section 1 or 8IL very clearly requires that all, emphasis, all records be disclosed brings voter registration applications within its reach. As this court has recognized, the use of the word all as a modifier suggests an expansive meaning of all as a term of great breadth. So when you go on into the statute itself, there are two exemptions. They don't relate here. So the Congress made a determination, certain things are exempt, and trial court in this particular case crafted another exemption that it simply has no limiting principle. And this court in the Project Vote case found that the way to remedy that is through redaction, and that was the Social Security number. We feel that. Beg pardon?
I'm sorry. In Project Vote, though, it was the applications themselves. It wasn't the underlying material, was it?
It was the applications themselves. That is correct. But our position is, and we believe that it would be supported that it includes anything that relates to the implementation of programs or activities of list maintenance. There could be any number of different kinds of documents that are generated incidental to a program or an activity of list maintenance. And in our position is,
Mr. Davis, is your point here that the district court acted prematurely? I mean, Project Vote was a summary judgment decision, and this is not. I mean, what specifically are you asking this court to do?
Asking this court to reverse the entry of an order dismissing on 12B6 grounds, remand it for the purposes of conducting appropriate discovery, and to the extent that the district court feels that there is something uniquely sensitive that needs to be protected, it can be done through the process of redaction, or it can be done through the process of, again, not providing the documents. But we simply haven't gotten to that phase at this point because of the entry of the order of dismissal under 12B6. That's the relief that we believe that would be appropriate under these circumstances, especially given the breadth of the interpretation of the public disclosure provision of the NVRA.
So you want, for example, information on everyone who was flagged for perhaps not being a proper citizen, not being a citizen who registered, tried to register or registered?
We are asking for the information that relates to the removal from the registration roll.
Well, the information mean the letter was sent, we have removed you. Did that, you mean that?
And in the response as to a indication of citizenship, one way or the other.
It is publicly available already, isn't it, Mr. Davis? People who are removed for non-citizenship?
But not the underlying documents as to why.
Okay.
So to me,
you want to know why they are not citizens? That's because, I mean, that's pretty much by statute, right? Why you're not a citizen. right? You weren't born a citizen, and you have not been otherwise naturalized.
There could be any number of reasons why someone would be removed on the issue of citizenship or non-citizenship, or maintained. It could go the other way. There could be an inappropriate removal. And it's just that these documents all fall within the ambit of what is discoverable under the statute. And again, I would like to point this court.
But that's not verified by Project Vote's ruling. Not the holding of Project Vote.
Well,
they were looking at a very specific request, and it said, and are you familiar with the part of Project Vote that dealt with the move and why move was, why it was protected in terms of privacy? In other words, information that's being in the process of being submitted or requested, in that distinction?
Yes, and I think the remedy of doing that was through redaction.
Yeah, but you want the requesting and the submitted. Project Vote was only looking at what was submitted, which is your completed application. But you want whatever they requested from that person in their response too, right?
Yes, and I believe that consistent with the intent behind the statute, which is one of transparency and accountability, that information will explain what the process is of the removal, as opposed to just the fact of removal.
But that will put no limitations on privacy at all. And if the point is, whatever the reason, they are no longer on the road.
Well, the project,
for example, they may say, well, for example, HIPAA information may have come up. Well, you said on this day you were doing this, and they submitted some medical records, for example. If you're on the requesting side, you want everything that might be in that complete response, bevy of responses to that inquiry they made as to whether or not you were a citizen. There would be no limitation on privacy. And that's what the Project Vote said. That's why MOVE was protected, because it was only what you submit. Basically, but what you submit as your application, but you want everything they may have requested. Which included law enforcement officers, right?
No. Problem at this point is in the 12B6 motion to dismiss context, don't know what we don't know. The documents, we don't know what the universe is. Clearly, if things do impinge upon rights of privacy, Project Vote basically says you need to balance those interests. And
okay, let me ask you here, Mr. Davis, if I could. Let's change the context away from citizenship, and let's talk about, let's say it's a mental health issue, and whether someone has the mental capacity to function. And what if the State Board of Elections has asked someone, if they have reason to believe that this person is mentally incompetent, or at least was judged incompetent months earlier, and needs to request an update on the status, and somebody wants to submit their doctor's letters as to their mental abilities, what kind of medicines they're taking. It seems to me, under your position, all of that would be discoverable, because it would go to whether they are potentially ineligible to vote. It seems to me that, see, what I'm concerned about is, if we agree with you, what else are we agreeing to? Everybody's life, it seems, would be put in the public view.
I guess I'm not making myself as clear as I should. We're not asking that there be an unbridled, unlimited disclosure of documents upon request. What we are asking, though, is for a process whereby the documents can be identified, and to the extent that there are documents, as you suggest, those may be protected. The Project Vote decision itself, and this is at page 338, it says, we do not think appellants' privacy concerns are unfounded. By requiring public disclosure of personal information, Section 8IL may conceivably inhibit voter registration in some instances. However, this potential shortcoming must be balanced against the many benefits of public disclosure. In the context of this case, And in the 12B6 determination, we never had an opportunity to balance those interests. And that's our position. I see I've overstayed my welcome here on the time, but and I appreciate the additional. If I have any further questions, I'm happy to answer them.
Thank you, Mr. Davis. Mr. Park?
Thank you, Chief Judge Gregory. And may it please the court. Ryan Park from the North Carolina Department of Justice on behalf of the North Carolina State Board of Elections. In this case, PILF has requested the identities and personal identifying information, including sensitive documents such as passports and birth certificates of individuals who are subject to a law enforcement investigation for possible criminal voter fraud. The State Board of Elections is under a statutory duty to investigate voter fraud or report possible violations to district attorneys. And as PILF was informed before it filed this lawsuit, their information requests overlap with a federal criminal grand jury investigation that has been sealed since January of 2019.
Well, Mr. Park, the district court determined that that was moot based on its underlying ruling. So it did not need to rule on a motion to seal and a motion to stay, if I'm remembering that correctly.
That's correct.
But as I understand what your opposing counsel has asked for, and maybe I didn't, he wants this to go back so that there can be discovery to identify whatever documents there are, and then have the district court address in the first instance whether they're entitled to some, all, or none of those documents, and if they're entitled to documents, what parts of the documents that they would be entitled to see. So it seems like to me at this point that the parties are asking the appellate court to engage in a lot of theoretical conjecture as to what the statutes may or may not apply to when we don't know what the basic underlying factual background is.
So I would make 2 points, Your Honor. First is, as you well know, that there was an ongoing consultation process before PILF filed this lawsuit, where the board disclosed a vast trove of information, everything that it could identify that did not reveal law enforcement targets, law enforcement sources and methods. And we gave the 2016 audit report, we gave an information file that had every single information on voter history for every single voter in the state of North Carolina, which included voters that had been removed and the reason for removal at that time. But to the extent that information overlapped with a law enforcement investigation, we did not disclose that information, and that led to this lawsuit. So we are already at that stage where the information that they are requesting that we have not disclosed would publicly reveal the identities of individuals who are being criminally investigated. And as the Supreme Court said in Douglas Oil, that would subject these.
Well, but that you don't have a ruling from the district court yet, as I understand it, to that effect. I mean, as I read the district court's order here, it just says, doesn't matter what these documents are, you can't have them. And it doesn't reference the law enforcement part that comes up separately. And that may very well be a determinative ground, but I don't see that you've got a ruling from the district court on any particular documents or the relationship to a law enforcement exemption.
I don't think that's quite right, Judge Agee. I think that the district court identified as the uniquely sensitive and vulnerable to abuse information as the identities of the people who are being investigated, and that has always been. All
right. So where do we find that? Where's that in the order or opinion or where do we find that in the record to know that that's accurate?
Well, what Judge Boyle said is that the disclosing the identities would raise the specter of immigration violations and possible criminal felonies. And that implicates this broader area of law. If there's any established principle in this area of law, it is the fact that one has been investigated or is being investigated for possible crimes is uniquely sensitive and vulnerable to abuse. And that was the fundamental basis of Judge Boyle's order, that if one has been being investigated, that raises substantial privacy interests, as the Supreme Court has recognized in Douglas Oil, and many other cases. There are legions of cases across the federal appellate courts where they have been emphatic. The Fifth Circuit in Briggs said it was disingenuous and frivolous to say otherwise, that whether you have been the target of a law enforcement investigation is not a privacy interest that implicates the constitutional right to informational privacy that this court recognized in Walls, as well as the Privacy Act and the Driver Privacy Protection Act. Sorry, yes.
Okay, Mr. Park, do you object to releasing the applications for the individuals who have been removed?
Yes, we would, Your Honor, and here's why.
What is the information? I had to pull the application off the website. I didn't find in the record any particular applications, and I'm assuming that the application that's on your website is up to date and accurate. What is there on this that you object to as uniquely sensitive for people who have already been removed?
So the fundamental issue here is their names. That's always been the fundamental dispute between the parties. Because if you reveal the names, you reveal information that has been gleaned from driver's records, because that's how you start this process. You say who has a non-citizen designation code in their driver's license application. And then you go to the federal databases, which are protected by the Privacy Act, and who has a non-citizen designation code there. So the source of the information are these two federally protected databases, which, by the way, neither of which were implicated in Project Vote. There was no federal source or federally protected source of information in that case, other than social security numbers, which of course were ordered to be redacted in Project Vote.
Well, where do we have any of this in the record, though? That's I don't know whether you're claiming you or the board itself is a law enforcement organization, whether there are regulations or statutes or adopted procedures that govern what the board does with this information as far as referring it to a state or federal prosecutor, or whether this is just a policy preference that the board has. I don't know where any of that is in the record and how or the district court is to make a determination unless it has that information.
So I would direct you, Judge Agee, to the joint appendix. It's starting at page 25, where that is our audit report, where we detail the process by which we verify citizenship information. And that information is all there in terms of the three-step process that the board uses. And there is a statutory obligation. I can give you the site. It's North Carolina General Statutes 163.22 that the board is required. It says the board shall investigate possible instances of voter fraud and refer them for prosecution. But here we are in an incredibly unique situation where there is a sealing order entered by the district court that says this information that relates to the grand jury information is so highly sensitive and vulnerable to abuse, I'm going to seal this entire case for 2 years. And I don't know if there could be a situation where it was more stark that this information is uniquely sensitive if there's been a sealing order. And I think that order, even putting it aside, exposes the dramatic reach, and I'd say alarming breadth of PIL's position here, which is that if they were informed that there was a sealing, that there was a federal investigation.
Well, all that may be true, but it kind of brings me back to the threshold questions. We don't know what any of these documents are that the foundation says it wants. And if we had a list, well, wait a minute, if you don't mind. If we had a list of what these were, that would make it a little bit easier for us to make this determination. Your point seems to be it doesn't matter what they want, they can't get it. Your opposing counsel seems to be saying, well, we get everything, but we don't know what these are.
So respectfully, that's not correct, Your Honor. The dispute is about the names. It has always been about the names of the people. And if the position that PIL takes today is that the names of individuals who are targets of a law enforcement investigation have to be redacted, well, that's a completely different case because that would alter substantially the privacy interests that are implicated there. But we gave examples, and this is in the record in the joint appendix, of what we produced prior to this lawsuit being filed. We gave the correspondence that had been sent out to all the people who had been flagged with names redacted. I mean, I guess we could give a copy of every single letter and have every single letter be redacted, but we just gave one copy with the name redacted. There are no documents that have been identified to us or that the board has flagged in its own investigation that it can produce that would not provide the names of the people who are being identified. And that has always been fundamentally what this case has been about.
And the district court basically ruled that you've given everything but the names, and the names are under the criminal investigation seal. So that's why I granted, I guess, motion dismissed because of nothing else to resolve at that point, I suppose.
Yes, that's our understanding of the district court's order. We obviously asked for the case to be stayed to allow the federal investigation to conclude before having to reach these issues. But I think that in this situation, even if we assume the court order is gone, the position of PILF, and it might have been altered today, and so you could speak to Mr. Davis about that, but the position that has always been that because of this Section 8I in the NVRA, that unless it's one of the enumerated exceptions apply, then it has to be disclosed no matter what it is. So it could be protected medical information, it could be information that is classified by the federal executive branch because it relates to national security information, and that is not a theoretical concern, just like medical information, that there are public records of cybersecurity intrusions and voter integrity efforts that are relate to voter list maintenance. And there is a classified Department of Homeland Security report that relates to North Carolina and cybersecurity intrusions that we have received. And I think under the plain language of Section 8 of the NVRA, under PIL's position, that would have to be disclosed without redactions. And so I think if there is a general rule that we would propose to the court, it would be that when there are multiple, that the NVRA establishes general rule of disclosure. We do not dispute that. We are firmly committed to transparency. And I think as PILF has recognized, we provide more information. The North Carolina State Board of Elections provides more information on its activities, on its voter file than most states. But it really puts us in an impossible situation when there are multiple inconsistent obligations that are imposed on the board. And so we would say that Section 8 requires us to disclose everything unless there is some cross-cutting legal obligation such as found in the privacy statutes. Yes, Your Honor.
Okay, so Mr. Park, I'm sort of, you almost anticipated my question, I guess, because I was going to ask you to tell me how you would write the opinion of this court. How would you interpret the language of the act regarding all records of programs and activities? What does that mean? Let's say, just say you're the judge, because we've got to think about not only this case, we've got to think about the universe of other cases that are out there.
Yes, Your Honor, and I agree. It's a difficult interpretive task because you can't read the statute in isolation. I think as Justice Scalia said in Branch, which we've cited, that it is the most rudimentary rule of statutory construction, that you don't read statutes in isolation, you have to read them in context. And so I think reading this statute alongside the other federal statutes that apply, and of course, if there are, intervening constitutional limits, which this court recognized in Project Vote, that has to be interpreted as part of that exercise. So I would just say again that all means all, unless there is some other cross-cutting obligation found in some other source of law. And frankly, as I've been preparing for this case, you just keep on learning of more and more potential situations where there's some other source of law that could impose a limit on what can be disclosed. I think Your Honor's thought of ones that I hadn't in terms of medical information, but there's classification procedures. There's no exception in the NVRA, in the text of the NVRA, that says except when there's a court order. And at least as this case was initially litigated below, PIL's position was that, if they serve a records request on us, and even if there is a non-disclosure order that has been entered by a federal court that overlaps with the request, we still have to give the information and risk contempt of the court order. And so I think it would be difficult to fashion an opinion that comprehensively addressed which documents may not be disclosed. And I think, that's the wisdom of at least part of Project Vote. At the end, it said, we do not attempt to address all the possible situations in which issues of implementing the statute can arise in the future, because there's just any number of situations that could arise. So I think a very narrow way to resolve this case is that when it overlaps with an ongoing criminal investigation, and especially in this circumstances when there's an actual sealing order that overlaps with the order, that the request does not fall within the scope of Section 8I.
Okay, Mr. Park, help us out again, though. The Project Vote, the sentence after the sentence you brought up, declined to address every particular question. The next sentence says, we do hold, however, that complete voter registration applications are subject to disclosure under the NVRA. And you're saying that they are not, with regard to those who are, excuse me, are potentially under investigation. There were no people potentially under investigation in Project Vote for committing felonies or maybe committing felonies. How do we reconcile that in writing our opinion?
Yeah, no, I think that is incredibly difficult, because if we disclose the applications themselves, which we agree are subject to disclosure in the general case, but we only include the list of people that are subject to a law enforcement investigation, we're of course disclosing their identities. It's almost like if a commercial marketer, this arises in the DPPA context. If a commercial marketer wanted all information in all North Carolinians who have blue eyes because to market some product, if we just gave the list of names, that doesn't say this person has blue eyes, but what it does say is these are the people who in the driver's records have said they have blue eyes. And so giving the list of names, the list of voter applications themselves would disclose the confidential information.
So you agree then, in writing this opinion from your perspective, we would have to distinguish Project Vote then? And
yes, Your Honor.
Okay.
Yes. And I think, as I've already mentioned, I think there are three huge ways where this is different. I think the nature of the privacy interest, there was no sense in which the people whose names were going to be identified, whose voter applications were going to be identified, would have been implicated in criminal activity, would have been publicly disclosed as the targets of a law enforcement investigation. Second is because of the source
counsel,
of the
even if we agree at that point that there's a law enforcement exemption, as I understand, part of the purpose of this NRVA is for a verification, so that you have this group of individuals that are subject to some form of law enforcement investigation. And at this point, there's a blanket exemption for all names. And I thought part of the point of the statute was there had to be some way to verify that that's accurate. How does that happen in this circumstance? I mean, how is anybody to know whether there's a list of 1,000 names and the board included 500 that aren't part of the law enforcement investigation?
No, I agree, Your Honor, that there is a true conflict here between the transparency goals of the NVRA and the privacy interests of individuals and the need for law enforcement investigations to be confidential. So I don't think that there is an easy way to resolve that conflict other than to say...
Why wouldn't you let the district court in the first instance look at whatever the list is And if it's all documented that these are subject to a criminal investigation, well, that's the end of it. But at least that way, even if that's done ex parte or under seal, but at least that way you would know that the list is accurate.
So we would not be opposed to, an in-camera review of that kind. But I think the final point I'd like to make, as I see my time is running out, is that the Supreme Court, other courts, this court has recognized that whether you have been investigated and then cleared is still private information that substantially intrudes on your privacy rights.
So following up with my last question, would it be acceptable from your perspective to remand to the district court for the district court to determine whether there is any information that does not disclose the identities of the people? In other words, if people were given a number and all the identifying information were removed, I think what Judge Agee is saying is, if we've got a situation where some information maybe could be disclosed, maybe that you haven't thought about or haven't considered, as long as the identities are protected, could we give the district court that job, or, from your perspective?
I think that, we are committed to transparency, and we, frankly, our entire position here has been an impossible one because we feel we're genuinely subject to competing legal obligations. If there were a remand for redaction of, to see if there were additional documents that could be produced but redacted, that's not something that we oppose in principle. But what we firmly believe is that the identities of anyone who has been investigated and the personal identifying information, they ask for passports, birth certificates, all of that personal identifying information is not subject to disclosure. And I would, also just note that, I'm limited in what I can say, but it's not clear that, a remand of that kind would be consistent with the district court's sealing order. And so, I think the court would just have to consider whether a remand of that kind would, implicitly dissolve that sealing order in some respect. So it's just a very complicated scenario. But what I can represent is that the information that we have given is what the board in good faith believes is everything that does not disclose identities.
So your position is then that you have given everything other than the name that you would have in a completed registration application. Is that right?
Yeah, and the personal identifying information that would track back to the name, like an address,
right. Like an address, right? Which was clearly the name. But other than that, that's either the name or directly translates into the name. You've given what was under Project Vote and completed registration information, correct?
That's right. That's right. I mean, we didn't produce redacted copies of every voter registration application with everything redacted. If Project Vote wants that, I think we could work with them. But we gave, examples, illustrative examples of everything that we think falls within the scope of the request that we have that would not identify. That's right.
Does the seal order cover everything you have not given? I don't know if I can answer that question just factually. Okay, but I don't want to go into something that get you in trouble about the seal, so maybe I withdraw it because it is a little touchy. I can see how that may be problematic. But the point is, though, that the motion to dismiss is technically without prejudice anyway, isn't it? Because you can always bring a request for documents, right? So
that's correct. They would.
Go ahead.
Yes, no. I think they could bring a further request, and once the grand jury concludes, and then we could talk about this without that complication. I would just emphasize that, of course, the same judge, as a practical matter, is overseeing both cases. He's been overseeing the
right.
federal investigation for 2 years, and so I think that. What I can say is that we can
I don't want you to go into that, but even more so reliable because the judge is handling both the criminal investigation that's the judicial side of it, as well as this case, civil. I understand. You don't need to go and think further there.
Thank you, Your Honor.
Yeah, but rightness of a case in terms of, that's the plaintiff's problem, isn't it? I mean, in terms of whether a case is justiciable at this point, right? I suppose that was the basis of the motion to dismiss. See, the district court says there's nothing else to do right now, unless we're going to mandamus the district court and tell them to withdraw your seal order. I don't think anybody's asking us to do that. Otherwise, go ahead.
No, I don't think so.
Judge Keenan?
Mr. Park, I know I said I was asking you my last question, so my apologies, but I guess the one thing I'm not really clear on as we conclude here with your presentation is, what about the names of people you have investigated and have cleared? The people who were okay, you've determined they're citizens. I imagine there are a lot of them. You know, the question arose and the information was stale. A lot of that information is stale. Have you provided that information?
So we have not, and thank you for that question, because I really do actually think that that exposes the most difficult issue in this case, which is whether someone who has been subject to a law enforcement investigation and then not charged or cleared, it has a privacy interest in that fact that they've been subject to investigation remaining private. I think, the Douglas Oil case, that is a grand jury case, and that says that, grand jury proceedings are secret to assure that people who are accused but exonerated are not held up to public ridicule. I think that whether you have been subject to a law enforcement investigation and even cleared is uniquely sensitive and vulnerable to abuse. And we know that because of, honestly, the circumstances in this case, that there have been instances where people who, simply because they failed to check a box, they failed to notice a box saying, are you a citizen in Virginia? That's how their forms used to be structured. They were flagged as possible non-citizens, and then their names and identities have been published and along with their birth dates, their addresses, their email addresses, their phone numbers, in some circumstances, their social security numbers, along with reports saying these people are felons, they should be prosecuted, they should be deported, and they brought suit, suing the plaintiff in this case. I think the final point I'd like to make, if I may, I know I'm over, is that the Virginia incident really shows the difficult situation that a board of elections is in, because after those citizens sued the plaintiff here, the PILF filed a third-party complaint against the Virginia Board of Elections, saying that they are liable for the defamation and the Voting Rights Act that PILF was being accused of, because they are the ones that had provided the information to PILF under Section 8I, and even though the board said that the majority of these people are actually citizens. And so we really are in a difficult position, but we think that whether you have been subject to an investigation and even cleared is still confidential.
All right, thank you, Mr. Park.
Thank you.
Mr. Davis?
Yes, just very, very briefly, I think council has overstated our position. We are simply looking to have the opportunity to have whatever records that would be responsive examined for the purposes of balancing the interests of privacy and the interest of disclosure, for the purposes of being able to determine what the actual implementation is of the program and activities that they engaged in regarding citizenship determination, verification. And the audit that they provide us is nice, but it's a summary document. It doesn't address the underlying program and activities and the actual implementation of it. So what we're asking is that this go back to the trial court, that there be a determination of what the relevant documents would be, and allow an arbiter to determine, or the court to determine, whether or not the privacy interests prevail or the disclosure interests prevail, and proceed accordingly. That's what we're asking.
Mr. Davis, then would you find acceptable a remand to the trial, from your position, a remand to the trial court to make a determination of any documents that do not, or portions of documents that do not reveal a person's identity?
Yes, I think that with regard to current ongoing criminal implications, I mean, there may be some that are no longer involved in that process, that I think would be disclosable. But I do appreciate the notion that if somebody is under criminal investigation and an active criminal investigation, that the identity could be redacted. But we, like I said before, we don't know what we don't know here because we never got that process.
Well, let me ask this. I think council has been rather forthcoming in this. If someone was flagged 10 years ago as to their citizenship, and it was determined clearly that the person is a citizen, you would want that information that that person was once flagged, a question about their citizenship?
What we're interested in seeing is what the
No, that's that's a very specific question. You want the identity of that person?
That would be, yes, because
I mean, why would you? I mean, wouldn't that be like you're looking for a scarlet letter to put on somebody?
Well,
why would that? Why would that have anything to do with the integrity of the list and the validity of the list? That someone was cleared 10 years ago, clearly they're a citizen, tax-paying citizen, no question, and they're a voter. You want to have that information, their name?
Well, no, there's two different levels to this. Is that disclosable? The answer is yes. You go to subsection 2 of the National Voter Registration Act. It's AI2. And in those, the identities of individuals and what have you are completely disclosed. Whether or not in that particular context, with regard to being red flagged and subject to criminal investigation, whether it's disclosable, I would leave to the trial court to make a determination as to whether or not it's subject to abuse or uniquely sensitive. We need to get to that step. That's the point I'm trying to make. If there are no further questions, I appreciate the opportunity.
Thank you so much, counsel. And Dan, we can't come down and shake your hand, but know that the sentiment is there and the appreciation is there. Thank you, counsel, so much for your argument. Be safe and stay well. Thank you.
Thank you.
Thank you, Your Honor.
Anybody need a
Good morning, Your Honors. May it please the court. I'm Geraldine Sumter with Ferguson Chambers Sumter in Charlotte. We represent Chaz Roberts in this appeal from the denial, or rather from the granting of the motion for summary judgment by the defendant. This is a case which involves a young man who worked in an all-male work environment. The defendant was a company that engaged in various underwater activities for power companies. In our case, the prominent one was Duke Energy Company. Our client was hired as a diver. There were various waterways where Duke Power had discharges of fly ash or other such things, which these divers were going in to clean out, repair various equipment or what have you. Soon after he began his employment with the company, he began to be harassed or subjected to offensive comments that were both subjectively and offensively, objectively and subjectively offensive. They came from co-workers, but also from his immediate supervisor, a fellow named Andrew Reiner. The affidavit and the testimony from Mr. Roberts is that this behavior was constant, repeatedly done on every job that he worked with Reiner as his supervisor, and it was pervasive. Now, the specific comments in the record included things like calling him gay repeatedly, constantly calling him gay, asking him questions like, how many dicks do you suck for money, calling him retarded, saying he had the strength of a retard. And Reiner admitted in his deposition that he may have called him gay and faggot. There was an instance where Mr. Roberts was photographed in a white coverall suit called a Tribex suit. And they took a photograph of it and did a meme and said that he was basically a bag of shit. Now, these comments, Mr. Roberts testified, were repeated. They were offensive to him. They were witnessed by other managers, including Reiner's manager, Brandon Neal, and they were reported to managers. He reported them to Brandon Neal. He reported them to Bruce Evans over 4 times. Bruce Evans is a higher level manager. And equally importantly, he reported them to a woman named Anna Glenn, who was the wife of the owner of the company, who at the time that he made the reports in November of 2015 and January of 2016 was serving in the role of the human resources point person. Never is there's no evidence that there was ever any investigation done. There's no evidence in this record that any action was taken to prevent this conduct. In fact, Mr. Roberts began work with the company in July of 2015, and his undisputed testimony is that this behavior began soon after he was employed and continued until the time of his discharge, so that at any point in his employment, a complaint from him had been taken seriously. It certainly did not result in the cessation of that behavior. And so any policy that the company had was not followed, certainly if followed, was ineffective in bringing the behavior to an end. The plaintiff did not report his concerns to the president of the company, but that failure to report them directly to the president of the company does not absolve the company of its obligations and responsibilities to investigate the matter. Now, the big question here is whether Mr. Roberts can make a same-sex sexual harassment claim without adhering to one of the 3 avenues outlined in Oncology. The last 2 don't apply in this case. There are no female comparables, and we have not made any allegations that Mr. Reiner, the person who is primarily the culprit here, was homosexual. But what we are, yes, ma'am.
Ms. Sumter, do we, if we agree with you that the trial court misinterpreted Oncology as giving required examples rather than illustrative examples, let's say we agree with you, what's our next step? Do we send it back to the district court to continue the analysis on the right track? Or do we go further and investigate the sufficiency of your allegations and the evidence regarding the content of what was alleged here?
Your Honor, I believe that the record presents you with sufficient evidence upon which to make a determination on the severity or the pervasiveness of the conduct. And so you could, in this instance, make that ruling. The evidence may not be as graphic as some other cases, but remember that in a sexual harassment case, the plaintiff can prove his case either by showing that the evidence was severe or pervasive. And certainly in this case, the evidence taken in the light most favorable to the plaintiff shows that it was pervasive. He says that it was constant, it was repeated. And even if the only thing that was said was that he was gay or a faggot, to have that repeatedly said to you, I would argue is sufficient upon which a decision of sexual harassment can be based. It's not a one-time thing.
Counsel, if I could ask you, this follows Judge Keenan's question. Ordinarily, if the district court applies the wrong standard, and if we assume here they applied the wrong standard as to Oncology, we would ordinarily tell the district court what the correct standard is and then send the case back and let them in the first instance apply that standard, having never applied it before, having used it. And even if we assume the district court was wrong, we did have cases, even though unpublished, that seemed to embrace the Oncology standard as being an exclusive standard. So, I mean, is there a reason we wouldn't let the district court do it in the first instance?
No, Your Honor, I gave you my preference. So yes, if traditionally you are allowing the district court to review the evidence under your approved, newly announced standard, then that would be appropriate.
But also it can be done if we do the standard and we find that by this record there's disputed fact.
That's correct, Your Honor. And please keep in mind, this is on summary judgment. And so the plaintiff here not only gets all of the facts determined in the light most favorable to him, but also all of the inferences. And my time is winding down, so I do want to address the issue of retaliation. Defendant claims that our client did not complain directly to Rick Glenn, who was the owner of the company, who they say made the decision. I say that the knowledge of these earlier complaints made to his wife and the other managers is imputed to him. And it is a question of fact whether he knew. I would ask you to consider your decision in Westmoreland versus TWC administration, which would allow a jury to make inferences on that evidence. Also,
excuse me, can you give us some context here? Does the record show how big a corporation this is? And is that relevant in the determination of imputing knowledge?
Your Honor, the record in this case shows that this really is a company that has management predominated by family members. The person who was the supervisor here, Reiner, testified that at the time of his deposition, he was one of two project managers, and that the other project manager was a son of the company. The person who was then doing human resources was the daughter of the company, and the vice president for operations was the title that the wife had. And
so are we talking then about a company that has, for example, fewer than 100 employees? Or are we talking about thousands of employees? Do we know that from the record?
You don't know from the record that they have thousands of employees, but they may have 100 or so, but it's not 1,000, or it was not at the time that these incidents took place. So my point is that because of the number of family members engaged in high-level positions, that the evidence is sufficient from which the inference can be made. And of course, the plaintiff shows you that even though they said they terminated him because of safety violations, that the value that they supposedly place on safety is undercut by the evidence in the record about them telling workers not to relate to safety issues to Duke Energy, and about other instances of safety violations that were not obviously taken as seriously as they claim safety is important to them. And I thank you for that, and will use the rest of my time on rebuttal.
Thank you, Ms. Sumter. Mr. Horowitz?
Good morning, Your Honors, and may it please the court. I'm Jeremy Horowitz with the EEOC. We're appearing as amicus in this case to address three issues with the district court opinion. First, that as Your Honors anticipated, the three examples in OnCal were intended to be illustrative and not exclusive. Second, that the district court erred to the extent it categorically refused to consider evidence of physical harassment just because it was facially neutral. And third, that the employer in this case did not make the necessary showing to establish an affirmative defense under Farragher and Ellerth. Turning first to the OnCal issue, the discussion in that case at 523 U.S. 80 to 81 it begins with what the court termed the easy case of same-sex harassment based on sexual desire, and then emphasized that that wasn't the only way to prove that same-sex harassment is because of sex. It then offered two examples before concluding that whatever evidentiary route the plaintiff chooses, the plaintiff always needs to prove that the discrimination is because of sex. Further underscoring that they aren't supposed to be the exclusive ways of showing discrimination because of sex are the facts of OnCal itself, where those facts don't fit within one of the three examples the court set forward, but the court still remanded to give the plaintiff the opportunity to show that the harassment plaintiff there had faced was because of sex. Nearly every other circuit to address this issue has held that those three examples are not exclusive. Turning to the second issue, under the Supreme Court's decision in Harris and this court's decision in the Connor case, a court addressing a claim of harassment should not, is supposed to consider the totality of the circumstances, which means that the court is not supposed to parse out which ones are facially neutral from those that are explicitly discriminatory, but instead should consider all of those. That's what this court explicitly held in the Connor decision and also in the Sunbelt Rentals case, that harassment can take multiple forms, and where there's evidence of harassment that's explicitly discriminatory, the court should also consider evidence of harassment that's facially neutral. A number of other cases have have found that as well, and the court therefore erred to the extent that it just refused to consider that evidence because it was not facially discriminatory. And finally, if I could go to the affirmative defense issue, to the extent this court wishes to reach that. Under Farragher and Ellerth, an employer is presumptively liable for the harassment of its supervisor. And when that, although it can, if that harassment doesn't reach the level of a tangible employment action, the employer can make out an affirmative defense. But to do so, it needs to prove two things. First, it has to show that it acted reasonably in preventing and quickly correcting any examples of harassment. And second, it needs to show that the employee acted unreasonably in failing to take advantage of any of these corrective measures, or in some other way in failing to avoid harm. And the employer here, a reasonable jury could find that the employer here didn't do either one. Its policy to address harassment wasn't It wasn't designed effectively, and it wasn't implemented effectively. And in addition, the response to Mr. Roberts's complaints weren't addressed effectively. And in fact, this is an issue that the defendant, by failing to brief it in the district court and by failing to respond to our arguments on this, the defendant is essentially waived. But to the extent this court wishes to address it, that the policy was not reasonably designed or implemented. And Mr. Roberts also acted reasonably in making his complaints to the harasser's supervisor, to another supervisor, made multiple complaints. And he also complained to the vice president and chief human resources officer of the company. And the company never responded, on the occasion that it did, it told him to, quote, suck it up. So that's not a reasonable response. And therefore, a reasonable jury could certainly find that it did not qualify, that the employer doesn't qualify for the affirmative defense. Unless your honors have any additional questions, then I thank you for your time.
Thank you, Mr. Horowitz. Mr. Thurman?
Good morning, your honors. Derek Thurman, sitting in Charlotte, North Carolina with the Shoemaker, Loop and Kendrick firm. As you know, I represent the defendant, Glenn Underwater, in this case. Just to start out, a sexual harassment claim, as we know, in the hostile or abusive work environment context, requires proof of unwelcome conduct, which I think has been established, proof that the harassment is based on the plaintiff's sex, or now, after Bostock, the plaintiff's sexuality, and conduct that is sufficiently severe or pervasive to alter the conditions of the employee's employment. And of course, it has to be imputable to the employer. The conduct here was not based on Mr. Roberts' sex or his sexuality. Notwithstanding Bostock, we still have Onkale. Bostock did not overrule Onkale. Bostock actually relied upon and cited Onkale. Onkale, in the context of the same-sex claim, had three elements. And this court has, as the court noted, in unreported decisions, held that these are the three ways you prove it. I'll address.
So, counsel, is it your position that Onkale is exclusive?
I believe it is, but even if it's not, I don't think it matters. There's no evidence in the record, as the EEOC argues, Mr. Roberts was insufficiently masculine, that he failed to conform to traditional stereotypes.
Well, if I could follow up, if I'm remembering the district court's opinion correctly, its decision centered only on the O'Callaghan elements. Is that right? It did not go any further.
That's correct, Your Honor. And I believe I agree with Ms. Sumter that there's enough evidence in the record for this court. If this court wanted to expand the Onkale elements, there's enough evidence in the record for the court to do so without remand. I think that would be judicially economical, but certainly it is within the purview of this court to remand if the court felt that Onkale needed to be expanded.
Mr. Thurman,
yes, ma'am.
Wasn't this conduct severe and pervasive? At first my reaction was, okay, men say things that are inappropriate. I've, my whole career in a predominantly male environment. But if this had been a woman subjected to this, we'd be shocked by this conduct. So why does anybody get a pass because they're a man for making comments like this?
Well, I don't think the evidence is as strong on severity or pervasiveness as my colleague suggests. In his deposition, Mr. Roberts talked about being called gay on several occasions and talked about the money comment on several occasions. Important to note, those are the only two comments that have anything to do with sexuality. Yes, he was called retard and some other things, but the only two comments he testified to that have anything to do with sexuality were being called gay and the odious comment about money. And he says that happened on several occasions in his deposition. Not until his declaration of support of summary judgment does he say, oh, it happened all the time. And even then, he doesn't tell us how often it happened. He doesn't give us specificity. He just said it happened a lot. So I'm not sure there's not enough evidence in the record for us to decide whether or not it might have been severe and pervasive, but there's just not enough evidence in the record for the court to rule on that. And I believe that's how the district court was of that opinion. Moving on, so if we're looking at Kale, my colleague concedes that we're only looking at one evidence, and that is whether or not there's credible evidence that the alleged harasser was homosexual and made explicit or implicit proposals of sexual activity. That just did not happen. He called him names, terrible names, but that's what he did. He called him names. Now, if we move beyond Kale, there's no evidence in the record to suggest
Mr. Thurman, based on your evidence, on your side of it, how many times was he called these horrible names?
It's not in the record, Your Honor. Nobody testified to that. Nobody, put any evidence to that.
Did you refute that it was ongoing?
I believe Mr. Reiner admitted to calling him certain names on occasion.
Okay, yeah.
I don't think either side. Yes, Your Honor.
Several occasions. So you didn't refute that. Several occasions.
No, I agree. This happened on several occasions. I just don't think it rises to the level of severity or pervasiveness.
Okay, well, pervasiveness, again, it can be in terms of I just can't imagine, like a jury, you never asked them to put themselves in the shoe, but can you imagine, you have to go to work and you're trying to make a living? And why should that come alongside with your work environment, those kind of comments? As Keenan said, man or woman being the target of it. It's disgusting, isn't it? To me, that to put someone through that because they have to work.
I agree, it's disgusting. I think the point is this was not because of sex. This was not because of his sexuality. That's the problem here. These weren't directed at him because he's gay or because he's a man.
But the evidence was, didn't he say that there was comments that, you're not carrying your weight, you have, you're effeminate in the sense of your ability to have brawn and those things like that. That deals with gender, doesn't it? He's saying basically you don't fit a stereotype of the gender that I should have. If you're a man, you should be able to do this. Or you should be able to come along. Isn't that related to sex or gender are covered in these comments, correct?
Yeah, I don't think there's any evidence in the record that there's any suggestion that he was effeminate, that he was not strong enough, in fact, he was told he had retard strength. I don't know what that means, but there's nothing in the record that he did not testify that he was told he was effeminate. He was told he couldn't cut it. The only evidence.
What's that? Why was he subjected to the question of whether or not he would perform fellatio for money? How much money? What was that? What was that about?
Well, I think that falls under the Seventh Circuit in Johnson v. Hondo. I think this is, excuse my language, says, most unfortunately, expressions such as fuck me, kiss my ass, and suck my dick are commonplace in certain circles. And they have no connection whatsoever with the sexual acts they reference. It comes down to the horseplay admonition that Justice Scalia gave us in Onkale, that there are workplaces where these things happen, and we shouldn't attribute that automatically to actionable harassment. But again, I ask you to carefully peruse the record, because there's just nothing in the record other than those two odious comments, and then the retard comments to suggest it's.
Mr. Thurston?
Yes.
Yeah. No. I didn't mean to cut you off there.
No.
What about the fact that Reiner wasn't really specific? Didn't he say, I think it's Joint Appendix 180, where he said maybe when he was asked if he called Roberts all those names? So, he could have said, I might have called him something once or twice, but, we didn't do anything. He said, he was asked, did you say these things? And he said, maybe. Doesn't that create more of an issue that would suggest that it should go to a jury rather than if?
Well, I think the problem is, severity aside, was this because of his sex or because of his sexuality? I mean, if we follow the EEOC logic, say Mr. Roberts could press a race discrimination claim if his supervisor had instead called him racial epithets several times over the course of employment, and that doesn't make sense.
Why couldn't they? Why couldn't he bring a case of race discrimination?
I'm not sure a white...
If someone had been called those things. Oh, you're saying a Caucasian couldn't have?
Yes. So as a white employee, Mr. Roberts could press a race discrimination claim if he were called racial epithets that are typically directed at persons of color. That doesn't make sense. This is the same argument.
Right, but he has a sexuality. Whether he apparently he's not gay, but he has a sexuality inherent in his personhood. So it's different from about whether a person is Caucasian, if they're African American, if they're, Asian American, all different groups that are subject to, although I guess less so because we are a very diverse country. And but sexuality is something that's inherent in everyone. So how do you get away from that?
Well, sexuality is as inherent in everyone as skin color is inherent in everyone. And here his sexuality is straight, and there's nothing to suggest that Mr. Reiner was abusing him because he was straight, because of his inherent sexuality. I guess we could have a reverse discrimination claim at some point, not in this case, but in other cases where someone's abused because of their straightness, as opposed to being abused because they're gay. Moving on to the,
I think that was what the 28J letter was talking about, though, in terms of Bostock, and how Bostock is saying that gender stereotyping qualifies as discrimination because. So how do you get away from that the comment in Bostock that the stereotyping is itself discrimination, or can be discrimination because of sex?
Well, there's no evidence in the record that there was any gender stereotyping going on here. If in fact, he other than just saying you're gay, I mean, saying you're gay doesn't suggest anything other than just using an odious term. I mean, it's just a ugly term. There's no suggestion here that Mr. Reiner thought he was actually effeminate or thought that he was actually not conforming to stereotypes. It's just a word he was using. It's just ugly comments he's using. There's no suggestion that he thought this gentleman was effeminate or was not making or matching certain stereotypes.
You mean other than the words he was using as alleged?
Other than the words. There's nothing outside of that other than the words.
But what else does need to be in terms of harassment? It's your words that cut like a two-edged sword often. I mean, why was there, at least as alleged, inferences here to be drawn in favor of the non-moving party? Why was there so much dwelling on these references to his sexuality being homosexual?
I think you're talking about an ignorant person who probably, I don't know this, it's not in the record, who probably opposes homosexuality and therefore thinks that calling someone names associated with homosexuality is offensive and just wants to call someone names.
And wants to hurt him, right?
Well, I would assume so.
And use sexual references to do it.
I would assume so. But again, as the Seventh Circuit held, this is not uncommon in some workplaces. And it's unfortunate, but it's not necessarily actionable.
I hope you're not defending the Title VII case on the fact that it's uncommon. I wish it wasn't uncommon. But that's the problem why we have cases like this, because unfortunately it's too common.
I agree with you. But on the issue of retaliation, there's certainly no evidence of knowledge by Mr. Glenn, who the handbook says is who you're supposed to report to. He did testify that he told Anna Glenn, who was Mr. Glenn's wife. That occurred over 3 months before the decision was made. And again, the decision was made by Mr. Glenn, and there's no evidence she ever told him. But the most important part in the retaliation claim is the but-for issue. But for his misconduct, Mr. Roberts' own misconduct, he would still have a job. There's no evidence that his complaints of sexual harassment had anything to do with the decision that was made ultimately to terminate him. He engaged in unsafe conduct on 2 occasions, was disciplined about it, actually sat down in the room with the owner of the company, made no mention of the fact that he was being harassed in the workplace, and ultimately was terminated. The evidence about the overall safety of the workplace, none of it addresses other employees engaging in safety violations. It's more of just a general gripe about certain things he was asked to do or not asked to do. You don't have any evidence, comparative evidence about other folks engaging. I think that's just a red herring. Unless the court has any other questions, I'm happy to cede the rest of my time.
All right, thank you, Mr. Thurman. Ms. Sumter, you have some time reserved.
Yes, Your Honor, thank you. First, Your Honor, I would say and ask the court to consider the Bostic decision in the context that Bostic says basically everybody of whatever sexual persuasion is covered by Title VII. And if everyone is covered by Title VII, then all of the stereotyping based on sexual orientation or perceptions of a person's sexual orientation or stereotyping is also covered by Title VII. And in this case, you have those comments which are sufficient to form the basis of a sexual harassment case without there being an overture of sex or an expression of an interest in engaging in some sexual activity with the victim, because what you have is these acts of physical aggression by the supervisor coupled with his demeaning and insulting comments, which I believe show an animus against Mr. Roberts based on what Reiner wanted to impress upon him as how he should act. And so there is no evidence that either of these men were gay, but to be subjected to the constant taunting and harassing is a demeaning way that this supervisor misused his position to cast a dispersion on Mr. Roberts in a way that offends Title VII. It was all because of his sex. Had he been a woman, we don't know what he would be doing, but he was a man and he was being subjected to a standard of masculinity, if you will, by these comments and by this physical aggression. And that's why the evidence of the physical aggression is important. Now, the defendant argues that there is nothing in this record to show that there was any interest or that Mr. Roberts was effeminate. Well, calling somebody gay and making these comments about him would suggest that his supervisor thought that he was or wanted others to think he was, since he made them in the presence of other co-workers. There is not in this record any denial by the defendant that the comments were inappropriate and had no place in the workforce. Now, the defendant is arguing that we cannot attach a retaliation claim to the fact that, due to the fact that they say that Mr. Roberts engaged in some safety violations. Well, the evidence in the record shows a number of instances where more egregious safety violations than a burn on the hand took place. and those employees were not disciplined. And so a reasonable inference that could be drawn from that, and the fact itself shows, is that their explanation for his termination is pretextual. If a jury disbelieves Mr. Glenn when he says that he didn't know that there were earlier claims of discrimination, that doesn't require a finding of discrimination or retaliation, but it is sufficient upon which a jury may base its decision. And court, yes, ma'am.
Ms. Sumter, it does seem to me that the weak spot in your case today is this issue of imputation of knowledge to Mr. Glenn. Do you have case authority that we can rely on that talks about what we consider when there is no direct evidence of knowledge on the part of the person who's been designated as the reporting individual?
Well, Your Honor, what we have is that knowledge to other managers can be imputed to him.
You have case law on that? Cases that we can consider that we could rely on for that proposition? Because I think that you can't just say because somebody's married to somebody, he must have known about it. I mean, that's...
I take your point, and I would refer the court to the cases that we cited in our retaliation section, including Howard versus Winter, where the court said that you can, if a defendant was negligent in failing after actual or constructive knowledge, to take prompt and adequate action to stop the behavior, that's going to be sufficient. But it is a factual question, Your Honor. And because it is a factual question, the defendant denies having this knowledge. A reasonable inference could be raised that his chief operating or his chief of operations or his human resources person in a company that is highly controlled by family members would have made him aware of that fact. And if a jury believes that he did not know, then we won't have that. But if the jury does not believe him when he says he did not know, the plaintiff is entitled to prevail on that retaliation claim. So it's a question, it's really a question of that.
Okay, so do you have cases where the knowledge is imputed to the decision maker in the absence of in other words, do you have any known or should have known cases that you want us to particularly take a look at?
Yes, Your Honor, the Howard versus Winter case and Struthers versus City of Laurel.
Okay.
And then thank you for your time here.
Thank you, counsel. Thank all of you, counsel. Can't come down and greet you as we would love to do as in our normal tradition of the Fourth Circuit, but please know we appreciate your arguments. Thank you very much. And we hope that you'll be safe and stay well. With that, I'll ask the Deputy Clerk to adjourn the court until this afternoon.
Thank you, Your Honor.
Thank you.
Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.